State and this honorable court.
Good morning. We're delighted to have with us this morning from Campbell University Law School, the Education Equity Clinic, and their clinic director, Lisa, Lukowczyk. Welcome. Glad to have y'all. Our first case this morning is State versus Boyette, and we will hear from the appellant.
May it please the court. My name is Jillian Frank with the Appellate Defender's Office. I represent the appellant, Mr. Boyette. I'd like to reserve 5 minutes for rebuttal. More than 40 years ago, this court held that the exclusionary rule does not generally apply in State versus Lombardo. In doing so, it also recognized one narrow exception when the officers who conducted the unlawful search knew the person was on probation. Today we're before this court because the Court of Appeals failed to address this exception in Mr. Boyette's case below, instead treating Lombardo as if it were a complete bar against the applicability of the exclusionary rule in probation cases. Mr. Boyette contends 3 things on appeal. First, that this exception exists in North Carolina. Second, that it's consistent with our law and public policy. And third, that it applies to his case. It's my intention today to focus primarily on the first 2 of those, although I would be happy to answer any questions that the court may have about the underlying search in this case. State versus Lombardo established the general rule that the exclusionary rule does not generally apply in probation revocation cases. In doing so, it looked at the reasoning behind the exclusionary rule, deterring police misconduct, and balanced it with the effect on the probation system, and found that although it would have just a minimal effect on deterrence, it would severely impact the probation system. However, the court noted that this was only the case so long as the officer conducting the illegal search did not know the person was on probation.
I think your friend for the state might argue that was an observation that the court made about the facts in that case, but not intended to be a holding that carved out kind of a clear exception that created a right in our state constitution that might not exist in the Fourth Amendment. What's your response to that?
Your Honor, the holding of the case has been interpreted by the Lombardo court itself in the dissent as this exception being part of the holding. So it has been treated by the court who wrote the opinion as part of the holding. It has also been interpreted as being part of the holding by the Fourth Circuit in Grimsley versus Dodson, and also by other secondary sources like the ALR on this topic. So we would argue that this was intended to be part of the holding of the case, and that it is part of the holding of the case.
So if it was a holding in Lombardo, there's also longstanding case law from this court. I mean, State versus Vestal is an example from this court that have said, and I think this might be what the Court of Appeals, although it didn't say so expressly, was getting at. We have this case law that says there's no variance between the state constitutional right, protection against unreasonable searches and seizures, and the Fourth Amendment in the U.S. Constitution. And we've said that in this idea of there's no variance, and then the Court of Appeals has taken that and repeatedly said how they described it is the rights are coextensive. So what I think scholars sometimes call lockstep. It's the same right in both constitutions. So should we be concerned that if we agree with your interpretation of Lombardo, we are sort of violating this longstanding notion that they're coextensive? Because you would agree in federal doctrine that the Lombardo principle does not exist.
Yes, after Scott, under the federal constitution, we are not required as the states to apply the exclusionary rule in probation cases. But there have been a range of different approaches by different states. Many have some sort of exception. Some of them are grounded in their constitution or in a statute. I would contend that this court in State versus Carter recognized a more robust protection under the Fourth Amendment. And part of that was based on, in looking at the exclusionary rule, deterrence of misconduct, police misconduct, is not the only aim of the exclusionary rule. This court also noted that one of the rationales behind the rule is to uphold judicial integrity. And here, that would mean, we don't want our courts to condone the protection of those who violate someone's rights. So I think it is in line with how we have interpreted our Constitution and the exclusionary rule specifically in this state.
The odd thing about Carter, though, is that the court in Carter talks about how it's really a policy question that should be decided by the legislature. And if it was
Yeah.
a constitutional doctrine, this court would never have said that. We don't give the legislative branch any authority to decide constitutional questions. That's, this court's core role. And so you can see an argument, and I think we may hear this from your friend for the state, that Carter also is not inconsistent with the notion that it's lockstep in both Carter and Lombardo. The court was not anticipating that it would become so clear in federal doctrine that the rule was something different, and if that did happen, we would evolve our doctrine so that it remained coextensive. What's your view on that?
I think the grounds for this exception in North Carolina extend beyond just how we interpret our Constitution. We also don't require probationers in this state to submit to warrantless searches without limitations. Our legislature has created limitations on when probationers can be searched. Under 15A, 1343, B13, and 14, there are certain limitations, like a probation officer has to search for a purpose directly related to supervision, and police officers, if they're conducting a warrantless search, have to have reasonable suspicion that a crime's being committed. So I think if we were to not have this exception, I think that would sort of be rendering those portions of our statutes sort of meaningless, because if the warrantless search was going to be okay anyway, and whatever was discovered was going to come in a probation case anyway, then it sort of renders meaningless those limitations placed on when they could be searched.
But we're here to decide what's constitutionally required, right? I mean, the legislature could adopt a known probationer exclusionary rule by statute, couldn't it?
It could, but I would say that here, Lombardo is the law in this state. So right now, it is stare decisis, and this is part of the holding of the case.
Well, it's stare decisis if we read it the way you do, right? But going back to Carter, one thing that I find problematic about your reliance on it is that several times since Carter was decided, like in State v. Garner, we've said that Article 1, Section 20, that the protections it extends are coextensive with the Fourth Amendment. So it seems like we've said, whatever happened in Carter, we're not willing to push those boundaries anymore. Why is that an incorrect reading of our case law?
I would say that even if that's the case, I'm not solely relying on Carter. I think that in terms of the public policy of the state, in terms of our statutes, I think that this exception and interpreting our Constitution in this way under these circumstances would be consistent.
So I hear you that you believe there's a state statutory grounds, but I don't see in Lombardo where there's a reference to the state constitution. Wasn't that decided on federal Fourth Amendment jurisprudence grounds?
It was, because it was decided back in 1982 before before Scott had made it to the Supreme Court, and there was more guidance from the U.S. Supreme Court and the federal Constitution, what's required by the federal Constitution for the exclusionary rule.
But in theory, the state constitution existed, and the defendant could have also raised a state constitutional claim in Lombardo.
They could have, but, you know, at the time, our state was interpreting it more broadly, and so I believe that at that point, they didn't see a need to rely on that as a backup.
And so then turning to this case, did the defendant preserve a state constitutional claim, or was his argument based on the Fourth Amendment federal constitution?
Specifically below in this case?
That's right.
So before the trial court, Mr. Boyette's argument was essentially, I suppose it was under the Fourth Amendment. It was not exactly using any specific, it was not pointing to any specific authority. It was mostly just on the grounds of this search was illegal, there was no reasonable suspicion, and things of that nature.
So if he didn't specifically raise a state constitutional right with the trial court, do we have any, is that even properly before us at this point? That is to say, what the state constitution requires.
I think it is, because Lombardo, it is part of the holding of the case, and this court has not reconsidered Lombardo. There are no cases since then that have looked at this exception, and so I think in deciding whether this exception still applies in North Carolina, I think it is before this court. The state is advocating for the exclusionary rule to never apply in probation revocations for any reason, but is this really what we would want in this state? This exception would only serve to discourage unlawful police conduct. And why would we want to disincentivize unlawful searches? While probationers do enjoy less privacy than our general public, they don't have no right to privacy. They're still entitled to be free from unlawful police action. The impact of adhering to stare decisis here and finding that this exception applies would be very limited. This exception would only come into play in a very narrow set of circumstances, such as where the violation is contested, which often they're just admitted, the person committed a new criminal offense, or a non-revocable violation that somehow involves the Fourth Amendment. There was some evidence to suggest that the police knew about his probation status, and the probationer raises the issue. So all of those things would have to be the case for this exception to apply, and this isn't likely to happen often. If it does, it's something that can be dealt with swiftly during the revocation hearing itself, essentially just like any other motion. As I noted before, the Court of Appeals didn't reach the merits of Mr. Boyette's case because they sort of just glossed over the exception, but I'd just like to make a couple of points about the underlying search here. As I mentioned, in North Carolina, we don't require probationers to submit to warrantless searches without limitations. So there must be, for a police officer to conduct a search, reasonable suspicion here. Reasonable suspicion, of course, is a relatively low bar comparatively, but it still must be more than an unparticularized suspicion or hunch, and that's exactly what we had here. At some point here, law enforcement either departed from or concluded the traffic portion of the stop. They had a canine do 2 laps around Mr. Boyette's truck, and the dog didn't alert. There was no evidence that he was behaving nervously or suspiciously. We have no evidence in the record to suggest that this was an area with a high amount of property crime, as the court below, the trial court, erroneously found.
Does the record reflect that the traffic stop had ceased before the dog started its sniffing?
It's unclear when the ticket was actually presented to him, which is why I said at that point they had either sort of departed from that portion of the stop or they had concluded it, because the testimony was unclear. It sounds like what happened was they stopped him. They were sort of asking him some questions, getting his information, trying to make a call into dispatch. And at that point, I'm not sure whether the ticket was given then or sometime later in the stop. But at that point, they sort of depart and decide to do the dog sniff. And when there's no alert there, at that point, I would contend that there was no reasonable suspicion to then go ahead and search. At that point, all there really was this lawnmower in the back of his truck that they somehow found odd or suspicious. But that in and of itself is not enough to be reasonable suspicion to conduct a search. And the state also has asserted that consent could be a reason that this search was authorized. But here, they didn't actually get explicit consent from Mr. Boyette. They simply asked him if he had warrantless searches, and he somehow indicated that to them that he did have warrantless searches. So this was more of a mere acquiescence to authority than any type of explicit consent. So I would contend that the state cannot rely on consent as authorizing this search.
But if we conclude that the search was lawful, then we don't even reach the question of whether the exclusionary rule applies or not, correct?
That's correct. That's correct. This court can also choose, as the Court of Appeals did not get to the point of considering these arguments, this court could also decide whether or not this exception still applies in North Carolina and address the stop, or this court could remand to the Court of Appeals with instructions to consider the legality of the stop. To reiterate, this is stare decisis, and Lombardo is the law. This has been considered part of the holding of Lombardo. This court should uphold its precedent, which I believe is consistent with how we have interpreted our Constitution, our probation statutes as they have been created by our legislature, and with the public policy of this state.
Just to piggyback a little bit on some of Justice Earle's questions, I think I heard you say that, at least on its face, Lombardo appears to be a case that was decided based on the Fourth Amendment, not Article 1, Section 20. Is that right?
That's my understanding, yes.
So if that's the case, why shouldn't we look at it this way? Lombardo was a statement of what our court understood to be required by the federal Constitution then, but the U.S. Supreme Court came along in Scott and said, no, the exclusionary rule doesn't apply to probation revocation hearings, even when you've got a known probationer situation. Mm-hmm. And so basically Scott effectively overruled Lombardo because it's a question of federal law.
I would contend that it doesn't overrule Lombardo, but rather it says that it's not required to apply under the federal Constitution. The state does not have to apply the exclusionary rule. The states can, and many do, choose after Scott to apply it in their state under various exceptions, and there are several states that just use the exclusionary rule in all probation cases, even after Scott.
I guess I'm getting to the fundamental point that if Lombardo was decided solely on the basis of the Fourth Amendment, then is it relevant to our question about the interpretation of Article, or does it control our interpretation of Article 1, Section 20?
I don't believe that it controls this court, what this court can decide in this case. I think this court has the ability to construe our Constitution in the way that it sees fit, and that our court could choose to decide whether our Constitution either requires or whether it's within, it would fall within our interpretation of our Constitution to recognize this exception.
So if it's not controlling, then is it really a stare decisis?
Whether Scott is controlling or whether
No, Lombardo.
Lombardo. I believe that it is controlling in that it is the last thing that this court has said about this exception existing. And that's sort of generally how this state is looked at as answering this question about whether the exclusionary rule applies in North Carolina. So I would contend that it is controlling in that respect. I just would contend that this court can choose to consider the question of whether or not our Constitution requires or permits this exception in North Carolina. For the reasons stated here in Mr. Boyette's briefs, this court should reverse the Court of Appeals decision and hold that the search is unlawful. Alternatively, this court can reverse and remand to the Court of Appeals to address the merits of Mr. Boyette's case in light of the exception. If there are no further questions at this point, then I'm going to reserve the rest of my time for rebuttal. Thank you.
Counsel. We'll hear from the appellee.
Good morning, and may it please the court. My name is Kayla Britt. I'm an Assistant Attorney General with the North Carolina Department of Justice, and I represent the state. There are 3 procedural issues that I would like to bring to your attention before we get into the substantive argument. The first is that this court and the Court of Appeals lacked jurisdiction based on an untimely notice of appeal. The trial court entered a judgment revoking the defendant's probation on April 30th, 2021. The appeal window then closed for that order 14 days later, which was on or about May 14th. The trial court then entered a duplicate and unnecessary second order on May 24th, and there's no authority supporting the suggestion that that second written order opened up a new appeals window. Then the defendant appealed on the next day, May 25th, from that final judgment. So I contend that the defendant's appeal was not timely, and the order did not create a new appeal window. Second, defendant did not make an argument at the trial court that the North Carolina Constitution or the exclusionary rule applied. He did not argue that the North Carolina Constitution was more broad or provided more protection than the United States Constitution. Third,
Can I stop you there? I know you have 3 points, but I do have a question about that, because it seems to me the strongest argument I heard from your friend is that Boyette in this case, and really any defendant who stands up in the trial court and says, my constitutional right against unreasonable searches has been violated, that is, because our case law says the rights are coextensive, that is raising both a state and a federal constitutional claim. And what I understand your friend to be arguing is, so because that was a doctrine that existed before Lombardo, that when this court decided Lombardo and created a principle, it was creating one under both the federal and state constitution. And then if the U.S. Supreme Court changes federal constitutional doctrine, it's still up to this court to either disavow the earlier decision here, Lombardo, that's in tension with that, or it remains as a state constitutional doctrine. What's wrong with that interpretation of how this plays out?
so Lombardo did not answer the question of whether the exclusionary rule applied to probation revocation hearings in North Carolina. That language was the language that appellant would argue would be precedential was the court interpreting what they understood the exclusionary rule to be at that time.
Well, I made that observation, your friend, but let's take the position that Lombardo did, in fact, make that a holding in the case.
Okay.
Then where are we? I guess what I'm asking is, does the lockstepping principle that we've articulated about unreasonable searches and seizures mean that it's essentially self-executing? If the Supreme Court of the United States changes Fourth Amendment law, does that automatically change our state law as well? Or does this court need to say, okay, that law has evolved and now our state law, constitutional doctrine has as well? So can Lombardo basically be overturned by the Supreme Court of the United States on state constitutional questions, or do we need to do that?
So the states are able to make the decision for themselves if they would like to provide more protection than what is provided in the United States Constitution. As I believe you mentioned Carter, Carter requested that the legislature decide on that issue. And the legislature actually asked this court to overrule Carter and to explicitly state that the North Carolina Constitution was the exact same as the United States Constitution. So we would argue that it would be this court's ability to side with the United States Constitution and say that exclusionary rule does not apply in probation revocation hearings. So the third procedural issue is that the defendant failed to state in the petition for discretionary review the issue for review. So it's a violation of the North Carolina Appellate Rules, Rule 15C, and it's not clear what issue is properly before this court. So based on these procedural issues, the state didn't have any opportunity to build a proper record, and we would ask this court to affirm the decision of the Court of Appeals or to hold that the discretionary review was improvidently allowed. The Supreme Court of the United States held in Pennsylvania Board of Probation and Parole v. Scott that the exclusionary rule does not apply to probation revocation hearings. As I mentioned with Justice Dietz, each state is allowed to make the decision whether or not they are going to provide more protection than the United States Constitution provides.
Before you dive too deeply into this, can you answer Justice Earle's question, which is if we believe that this search is lawful, do we have to reach this question about the exclusionary rule in probation revocation hearings, or does that become advisory?
I'm not sure I understand the question, Your Honor.
So what happens if we decide the search was lawful? The search and seizure? The dog intensely sniffed, that was enough to provide reasonable suspicion.
I'm trying to process your question. So if they found that the search was proper and therefore nothing would have needed to be suppressed.
Right. You can proceed.
I'm sorry, Your Honor.
I think what Justice Riggs is asking is if we conclude that it was a reasonable search, the Fourth Amendment and our state constitutional protection in Article 1, Section 20 are not implicated, do we need to get into a tricky question of whether lockstepping applies here or we have some different doctrine, or can we simply say we need not reach that, there was no violation, even if we thought Lombardo had a stricter holding than what you say it does?
Yes, Your Honor. I would say that we would not need to get into the tricky argument. And even if it was unlawful, the United States Constitution provides that even evidence that does not satisfy the Fourth or 14th Amendments can be admitted in probation revocation hearings. So the purpose of the exclusionary rule is to deter law enforcement officers from conducting an unlawful search for the purpose of getting conviction. We know that in probation revocation hearings, we are not seeking a conviction. We are simply determining whether the probationer has met the conditions of their probation or if they have continued to violate some rule that the judge or the court set for them. The Supreme Court of the United States has decided that the cost outweigh the benefits for applying the exclusionary rule and that the deterrence is minimal. A few things that would hugely complicate our probation revocation system would be considerations that we might have to have motions to suppress in probation revocation hearings, or discovery to follow that, a ruling on a motion to suppress, appeal rights that arise from the motion to suppress, or potentially MARs for failure to file a motion to suppress. We would argue that this would be a trial within a trial and that it would overly burden our system. We would also reiterate the fact that We understand some states have taken the approach, but for us, we would say that the cost is not worth taking that step. Allowing the exclusionary rule to apply in revocation hearings would take a non-adversarial and more administrative-like procedure and make it more adversarial. It would disincentivize the court from allowing probation at any point, and it creates financial costs from the trial-like extenuation of the process. Again, State v. Lombardo did not address whether a specific exception exists. This court was wrestling with the idea of the limited deterrence that was previously mentioned, and when Scott came along, Scott decided that the exclusionary rule should not apply. So Scott represented this evolution of the exclusionary jurisprudence that Lombardo was wrestling with 40 years before that. So the state would contend that based on the limited deterrence effect versus the cost of litigation to include the extra necessary steps such as the motions to suppress and the steps that come after that, in addition to courts maybe not choosing to implement probation because they're trying to avoid all these extra steps. We believe that in North Carolina should follow Scott in holding that the exclusionary rule does not apply to probation revocation hearings. We would even offer to this court that Lombardo kind of left the decision open, and we are asking this court to maybe even to decide that issue today and say that explicitly this wasn't decided in Lombardo, but maybe it's decided today, and the exclusionary rule does not apply to probation revocation hearings. We might also ask this court to overrule Carter. As we mentioned before, this court asked the legislature for their opinion on the matter. The legislature has asked this court to overrule Carter, and that has not been done. So that would be in alignment with the state's argument today. Based on the procedural issues that I provided, this court should affirm the lower court's decision or hold that the discretionary review was improvidently allowed. Should this court hold that the case survives those procedural challenges, we would ask again to hold that the exclusionary rule did not apply, and to hold that the exclusionary rule in North Carolina is the exact same of that from the federal. Should this court hold that an exception exists, this court should remand to the trial court for a proper motion to suppress hearing to be filed in defendant's probation revocation hearing. And we would argue that that in itself would overly complicate this case as well as the probation system overall. If your honors have no further questions, the state will rest on its briefing record at this time.
Thank you, counsel. Rebuttal.
May it please the court. I first just want to respond that I believe it would be improper for this court to overrule Carter in this case. Carter is not before this court. It has not been briefed, and it's not required to resolve this case. I also want to respond about my colleague's assertion that this exception would create a trial within a trial situation. In other states that have this, essentially all that happens is that the probationer files a motion to suppress or makes an objection on those grounds at the probation revocation hearing. The court then makes findings of fact about whether or not the search was lawful and the officer knew the person was on probation, and whether or not, what is the correct remedy at that point, whether applying the exclusionary rule is the correct remedy. So essentially, this can be done in just one proceeding, just as we already have now. A lot of times, these revocation hearings go exactly like the one here, where there's probably about 1 or 2 witnesses. Often, the state will call the officer, if it involves some kind of, later criminal offense, then they'll call the officer who arrested or did the search, and you could get all the evidence you need to answer these questions and determine whether or not the search was lawful and whether this applies by that one witness's testimony. So this would not create a lengthy amount of, litigation. It would not need to be in another proceeding. So I think that the state overstates what would actually be the practical effect of applying this exception here.
I'd like to go back to the notion that Lombardo adopts the non-probationer exception, because if you look at the end of that opinion, at the actual holding of the case, our court said simply, we hold that the exclusionary rule should not be applied in probation revocation hearings. Isn't that the actual holding of the case, and the statements about the non-probationer, aren't those merely dicta?
I would contend that no, that is not solely the holding of the case. I think under the facts of that case, they said that this exception would exist in North Carolina, but they didn't need to apply it in Lombardo. So when they restated what the holding was at the end, perhaps they were just giving the more general holding that applied in that case, which was that the exclusionary rule was not going to apply. But if you look at the dissent says the majority's holding that evidence will not be excluded, quote, so long as the enforcement officer does not know the defendant is on probation, end quote, unduly complicates the law. The majority gives no hint as to what kind of knowledge would invoke the exclusionary rule. So the dissent considered this to be part of the holding of the case. So I would contend that if that's how this court, when they were writing Lombardo, understood the opinion to, if that's how they understood the opinion at the time, then that's an indication that this is part of the holding. I also just want to make the point that if this exception does not exist in North Carolina, then when police at the moment of a search know that the person is on probation, they would have significant incentive to conduct an unlawful search, even though they know that the evidence would not be able to be used in a criminal trial because it could still be admitted in a probation revocation. The police would have nothing to risk here. The defendant, if it was excluded from a criminal proceeding, could still have their probation revoked and end up serving time anyway. And for this reason, it would be unfair. So I believe that this exception would further our rationales for the exclusionary rule, including judicial integrity. At this point, if the court has no further questions, then I just want to ask the court to overturn the decision of the Court of Appeals and hold that the exclusionary rule does have an exception and it applies in this case, or alternatively to remand to the Court of Appeals to decide if it applies to these facts. Thank you.
Thank you, counsel. Mr. Clerk.